Good afternoon, everyone, and thank you for joining this Youth Laborist webinar. My name is Florence Don, and I will be facilitating the session for you today. Today's webinar will be given by a set of panelists, all from different member firms of Youth Laborists. Today, we have lawyers from Italy, Poland, the UK, and the Netherlands. Before we start the webinar, I would like to clarify a couple of points on the housekeeping side. If you have any question during the webinar, you can use the Q&A tab to send your question to the panelists. We will try to answer as many as we can. You can, of course, also reach out to the panelists by email after the webinar. I will now turn over to Melania Soncin from Tofoletto dello Catamaio e Soci, the Italian member firm of Youth Laborists, to begin the session. Melania, you are welcome to start.
So thank you, Flo, and thank you everyone for joining. So it's been, I think, since the COVID pandemic, since 5 years, that we have seen a development in new forms of global mobility. And also we have experienced new expectations by employees, new needs by employers. So employees now sometimes ask their employer, because they are seeking a better work-life balance, to be allowed to work from their home country without relocating to the country of the employer. At the same time, we have employers who do not find the talents they need and therefore have become more flexible in looking for employees also in other countries. But maybe before entering a new country, before setting up a branch, a subsidiary, they want to test the country in a more flexible way, limiting the administrative burden. So in this context, we have seen, let's say, the rise of the employers of record. So these are companies who offer to support the employers in managing an international workforce, so hiring employees who will then service the end user. But, you know, when we speak about employees working for third parties, it is easy to fall under the umbrella of the leasing of personnel legislation, which has differences in each country. Sometimes it's very restrictive, and we see it sometimes becoming applicable also in other cases, such as secondment service agreements. So it is an area of the law which is highly regulated and in which it is always important for the EORs, for the end users, to be careful and to understand the peculiarities of each country, not just assume that, you know, we all have the same rules. So the purpose of today's webinar is really to shed a light on this phenomenon, have a better understanding of how things may change from one country to the other. And we will be doing this thanks to the support of our speakers. So we have Amy Navins from Lewis Silkin in the UK, who is the head of their global mobility practice. We have Hilda Viarda from Bronx, sorry if I mispronounce this, Hilda in the Netherlands, and she's one of the most recognized employment and labor lawyers in that country, and Michal Kapczyk, who is partner at Czakowski in Poland and is also the head of their immigration and global mobility practice. So moving to our panelists, my first question for you is, are employers of record regulated in your country? And if so, what is the setup which is most common? And Michal, if you want to start.
Yes, absolutely. Hi, everybody, and thank you for having me here. So employer of record in Poland as a concept, separate concept, doesn't really exist, but there are obviously companies offering such services. And to give you an overview how these companies are operating, let me tell you that in Poland, we can have a temporary work that is executed within the temporary agency scheme. We can also have outsourcing of services, and you can also have a leasing of personnel. The last one, leasing of personnel, is not allowed, is illegal. That's why employer of record, they use the opportunity and use the scheme of outsourcing of services. In practice, it looks like that AR signs a contract with its client for performance of certain services, which are later executed by the employees, simply pointed out by the client. So someone else, a third company, third party is actually benefiting from these services, but the employees are formally employed by the EOR. And even though this is not regulated by law, it's legal. I mean, like, if you organize it well and you eliminate all the potential risks that we will be later discussing about, you can use that services, and you can, of course, offer that services as employer of record. The structure itself is often used by the foreign companies who do not have a permanent presence in Poland. And obviously, if they want to hire one or a few people, and it's not probably worth to establish and incorporate a company in Poland. And then EOR brings an answer to this problem. Very often, the employees of such companies are foreign nationals. Everybody's benefiting from this scheme and from this solution. And even though this is, as I said in the beginning, not regulated by law, in fact, it answers to many questions and fulfills many needs. In practice, we are discussing about war for talents, and also in Poland, it helps to accommodate the needs of employers and the need of the employee to have a former employer and to work legally.
So thank you, Micha. And Amy, what about in the UK? What's the landscape there?
Yeah, so in the UK, similar to Poland, we don't have a specific definition of an employer of record. Broadly speaking, when we're talking about an employer of record, we're talking about a company that's a third-party organisation contracted to take responsibility for employing and paying employees. This includes dealing with the employment contracts, payroll, taxes, visas, sponsorship, benefits and insurances. And the EOR employs the individuals directly and supplies them to the end user company, and they generally charge a fee for that service. And the end user is able to retain the ability to direct and supervise the individuals on the ground. So in the UK, there's no limits on the length of time for which an end user company can use an EOR. There's no limitations on the reasons why they're using an EOR. And you can engage the individual through the EOR for an indefinite basis or for short-term project basis as you need. And the EORs supplying labour will fall within the UK's legal regime governing the supply of labour. For example, in England, Wales and Scotland, we have regulations called the Conduct of Employment Agencies and Employment Business Regulations, commonly referred to as the Conduct Regulations. And in some cases, the Agency Worker Regulations will also apply. However, if an EOR is providing a service, as is often the case, how EORs are set up, then they generally are not considered to be providing labour. And how an EOR is set up really depends on who you're engaging with and the setup that they have. So as we'll talk about later on, it's very important that you understand how the service is being offered by the EOR.
Thank you, Amy. And Hilda, what about the Netherlands?
Yes, thank you, Melania. Yeah, the concept of an EOR is understood in the Netherlands to be more or less the same as Amy just described for the UK. So the EOR acts as the formal employer, taking on mainly the administrative side of HR, basically. Now, contrary, though, to many other jurisdictions, including those here on our panel, the concept itself has a statutory basis in the Netherlands, and it is already also known since the early 90s in the Netherlands, mainly in the specific industry of restaurants, etc. But it developed there in that branch and became sort of more a form of temporary agency workers. So the offering of personnel by temporary agency employment agencies. Well, I won't be bothering you with the whole debate that sparked within our government in the Netherlands on that. However, it resulted, the whole debate and discussion in 2020, in a clear definition in the Dutch Civil Code of what can be considered as what we refer to in the Netherlands as a payroll company. And across the globe, that's more being referred to as an employer of record. It is an employer of record in the Netherlands is in fact sort of a specific form of this traditional temporary employment agency, though not to be confused with them. because the difference is that an employer of record does itself not search the candidate or the worker and the employee to be hired. This searching and selecting of the candidate is done by the end user. So there's no allocative function, basically. And the worker can only, with the explicit consent of the end user, be allocated to another end user. So there needs to also be a form of exclusivity. And that's the distinction really between an employer of record and a temporary agency, a worker agency. Now, there's currently, I think, around 3% of the total workforce in the Netherlands that is actually being employed through an employer of record. And like in Poland, it is indeed, the concept itself is often used by foreign companies without local presence, though it's likewise being used by local companies for all sorts of reasons. Yeah, it is quite a known concept in the Netherlands for quite a while already, Melania.
So thank you, Hilda. So from all your contributions, what I understand is that basically deregulation, the concept of employer of record, let's say as a brand, may in the end differ in each country. So you really need to then look into it to understand the company you are engaging in, what is the setup you want to, what is the needs, the respective needs, and so on. Just to give a highlight from the Italian, let's say, perspective, again, you need to see what is the service, the activity that is being provided. By way of example, if your need is to have personnel leased, even in Italy, this is of course allowed, and actually it's been regulated for years. So the important thing is just that the employer of record registers to the Ministry of Labor, and there are a number of formalities to be complied with and restrictions, especially on the end user, because the end user can only hire a certain number of leased personnel with respect to their open-ended employees in Italy. So there have been historically a number of rules to be followed in this area, which need to be considered to avoid liabilities, because otherwise we also have strict sanctions in Italy in case of unlawful lease of personnel. They have recently been strengthened, so they also get to criminal sanctions. So what is important is to know how to navigate our landscape. And this actually leads me to my second question to our panelists. So in your countries, what happens if mistakes are made and there is a problem in the setup with an employer of record? What are the sanctions that companies are facing? So Michal, if you want to start.
Yeah, absolutely. Thank you. So I can see that Polish concept, or actually non-concept, is very similar to what happens in UK, and as usual, Netherlands are ahead of everybody, also here. So I wanted to point out once again that in Poland, EORs are not providing labor, they're providing services. This is the employment work agency that is providing labor. So for example, company A says to the work agencies like, please provide me 10 employees to do the job in my place. And this is how the employment agency works, temporary work agency. EOR works differently. So a client says, I want to have this service executed. And then EOR is actually sending people to execute this service. So the contract between the companies does not mention that there are like people behind this. Obviously they are, because they execute the service, but the nature of the contract is to execute the service between the companies. And this is how EOR is organized in Poland. And jumping to conclusions, it may also bring certain risks. Firstly, authorities may actually find out that this is leasing of personnel, and leasing of personnel in Poland can be only executed within the temporary work agency scheme. So the company that is actually providing such services may face a fine. Second point is actually also about the potential lawsuit that I can imagine unhappy employee being employed by EOR says that actually my employer is a different company and the one that orders the services. So I can imagine the situation where the employee brings the case to the court saying that this is not my employer. My employer is the company that actually ordered these services. And this may also bring additional risks. Firstly, payment of due Social Security. At this point, the case is not that complicated because the Social Security institution should, in such case, transfer the premiums paid by the EOR to be calculated towards the premiums that should be paid by the actual employer. But with personal income tax, the situation is a bit more complicated, because if the actual employer is actually a foreign company, and this is how it usually works in Poland, that the clients of EORs are foreign companies, personal income tax is due on the side of the employee. So the employee, if the things go wrong, the employee would be tax liable and would have to pay for the personal income tax for the last a bit more than 5 years, because that would be the tax limitation. So there are several things to be considered. But again, if this is well organized and accommodated, actually the risk can be mitigated. And this is how it works in practice.
Thank you. This is very interesting. And if I can comment, it seems that Poland and Italy on this, let's say on the claims we more commonly see are quite similar, because this happens in all the cases where we have two companies and one employee. In Italy, if it's under a service agreement, a secondment, a lease, no personnel, whatever, if they are unhappy, or if one, maybe the other company is the strongest or whatever, there is always, this risk for the employee that wants to move to the other company, possibly say the dismissal, is null and void because served by the long employer. So that's why I think it's really a hot topic, how to really manage carefully the three-part, let's say, relationships. And Hilda, what is the view from the Netherlands?
Sorry, had to unmute myself. Yeah, it's interesting because there's not so much of a risk in the Netherlands in terms of compliance, because of the fact that it is a statutory concept in itself. And obviously, it's strongly recommended to make sure that the EOR that you engage with as an end user is indeed a certified company and has the required certifications, because that helps you when it comes to potential liability of the end user for correct payment of Social Security premiums and wage tax withholdings by the employer of record. Should they fail to do so, the tax authorities can indeed go to the end user and hold them liable for this. So there, in that sense, there's this chain of liability. But in terms of other regulations, yeah, there's not too much to worry about in the Netherlands.
Thank you, Hilda. It seems the paradise. We're all moving to the Netherlands. At least as lawyers, it will make our...
I'll come to a different topic later, which is going to make everyone wonder.
That's nice. So, Amy, what about in the UK?
Well, I think it's really interesting having Hilda in the Netherlands in this call, because it just shows that having a legislation that clearly addresses this concept makes everything much more straightforward. And I think when you look at the UK and Poland and Italy, we're trying to force legislation which wasn't necessarily set up for an EOR model to try and encompass this. And the EOR legislation, as you mentioned earlier, Melania, is massive. The labour leasing legislation, it covers the secondment all the way to these EOR models. So, it's when we're looking at this legislation and the risks around this, it is quite difficult to navigate. But in the UK, again, it all comes down to whether or not the AOR is providing a service or providing labour. If they're providing a service, then it's a business-to-business contract with regard to the provision of service, and that service should be set up very clearly and correctly. And then you don't have necessarily the labour leasing legislation applicable. However, if it is considered to be a labour arrangement whereby labour is being provided, then the conduct regulations apply, as I mentioned earlier, and the Employment Agency Standards Inspectorate is responsible for enforcing compliance with those conduct regulations. And that can lead to an EOR being inspected by the inspectorate. And if they're found to be non-compliant with the conduct regulations, then there can be penalties and fines that can be issued against the EOR. And then obviously reputational risk for the end user engaging. There's also potential risk, as I mentioned before, with the agency worker regulations if the individuals provided are found to be agency workers and if there's not been any compliance by the EOR. When you don't have the arrangement set up properly and there's exposure then to the end client, it again comes back to this point of whether or not the employee seeks to argue that they're actually a direct employee of the end user and not by the EOR, which is obviously the whole thing you're trying to negate by utilising the EOR arrangement. And obviously, if that's set up correctly, then you're able to negate that. But if there's things that's not quite right, then there's that potential exposure. However, the risk of that being successfully argued so far in the UK is low. But again, you need to make sure the arrangement is set up nice and correctly to ensure that that liability is managed. There's some proposed tax changes coming in April 2026 relating to umbrella companies, and there isn't clear guidance whether or not the EOR would fall into that umbrella company definition, which potentially passes up the obligation, well, the liability, sorry, with regard to income tax and national insurance being properly accounted to HMRC up the labour chain to the end user. But that hasn't been fully developed from the tax legislation that's come in, and that's something that obviously will be kept an eye on over time. But fundamentally, what we're saying here is, as long as your arrangement is set up properly and you're confident with that, you should be able to mitigate all of these risks.
And thank you. I mean, these points are very, very interesting and very, start to really feel the sense, I think, of the different problems that may come up. And are there other practical practical issues I think you need to consider? I would say with you, if you can answer on this.
Of course. And this is where we're looking at the commercial agreement that you have between the EOR and yourself. So you've had the commercial contract, you've decided to go with the EOR, and it's really important that you read those commercial terms properly. And it might be something that you as a HR professional maybe aren't as familiar with reviewing commercial contracts for these types of arrangements. So it's really important that you make sure you bring in your legal team, your finance team, etc., to review, because you want to look at things like indemnity clauses, conduct of claim clauses, indemnity caps, whether there's any unforeseen additional costs addressed within those terms. And it's really important that you're aware of those, so when you're going into this agreement, you fully understand this. It's not necessarily for the EOR to explain all of this for you, it's for you as the end user to make sure that as a business you're considering those terms carefully. It's also really important that you understand your labour supply chain. And by that, we mean you as the end user engage with the EOR, and then is there anyone else in that chain behind the EOR who will be providing that labour? Because it's not uncommon that an EOR might subcontract the on-the-ground engagement to another company. So you just want to be super clear on who's involved in that labour chain, so you can ensure that local compliance, and you can make sure that the employer, the actual business that's employing the individual, is complying with all the legislation in that country to make sure that your employee, well, your end, because they're not your employees, but the people that are being provided to you are being treated fairly, because that's what you want to make sure when you're using these companies, that you're engaging with a really reputable company that is operating fair and legitimate practices. You also want to think about benefits, and this is something that I see is sometimes overlooked, whereby you might be thinking about offering someone an engagement via an EOR, and you ordinarily have all of these benefits that you offer to employees, but because the EOR will become the employer, they need to be able to offer those benefits. So you just need to make sure that your EOR is able to facilitate the terms that you're looking to provide. And you don't want to get into a situation whereby you spend a lot of time negotiating or finding a candidate and then subsequently can't offer or facilitate the provisions that you wanted to. So that's just quite important there. One big thing that you need to really consider before you even think about using an EOR in these types of arrangement is permanent establishment risk. And that's not something that an EOR would be advising you on. It's completely beyond the scope of their terms of what you're engaging them for. Permanent establishment risk is whether or not, as a result of you having a business or a presence in another country, You potentially have liability for business-related taxes, including corporate tax and other obligations. And that arises when you engage lots of different arrangements overseas. So it's not a new thing that only applies with EORs. It applies in lots of different arrangements whereby you potentially are operating in other countries. And that's something you really need to be thinking about, having specialist advice from your corporate tax team if you have an internal corporate tax team, or your accountancy advisors, to make sure that you're really considering that and mitigating any risks around that. Things like IP, intellectual property, are also really important. And the reason it's important is because you're obviously not going to be, as the end user, the employer. And IP, depending on every country, generally is provided to the employer that the employee is working for when they create this IP. And there's often very specific clauses that need to be in the employment contract. Now, you obviously want to make sure as the end user that IP passes to you. So you need to make sure that within the underlying employment agreement, you're comfortable with the IP clauses and that they align with local legislation. And then separately, that your commercial terms then have the relevant wording needed to ensure that that IP is passed on to you. You also might want to really be careful in terms of understanding how you might be going about enforcing any breach of these IP clauses, because again, that's going to be different. Who's going to be enforcing it? Is it you, the EOR? How does that work? What's the realistic chance of enforcing that? And that might not be relevant for lots of roles, but obviously anyone who's working in roles where IP is important, that's really something you need to be honing in on and getting comfortable with. And it's totally able to be done, but you just need to make sure that you're aware of how that is managed. Post-termination restrictions and confidentiality is really important as well. Again, in a normal employment arrangement, the post-termination restrictions relate to the employer protecting their confidential information and their business. When the EOR is the employer, the post-termination restrictions are different, because obviously the business being protected is the EOR. How does that extend to the end user's business? So you need to understand, again, how are we making sure these are correctly drafted in the underlying employment contract? How does that flow through into the commercial terms? And how does that get enforced? So it's, again, making sure you're aware of that relationship, having this intermediary there, and how do you manage that with regard to post-termination restrictions. In some countries, it's difficult to enforce or not able to, so you just need to be aware of how this is slightly different to home employees, who you might be incredibly familiar of how all these principles work, but obviously we're now dealing with other jurisdictions and other legislations. And that leads on to the management of the individual's day-to-day. Different EORs have different setups in terms of the level of support that they offer. These individuals will have employment rights ordinarily in the country in which they're working. They'll have employment contracts generally under the laws of the country in which they're working, which is different to where you're generally working when we look at EORs in the usual way that they're utilised, which is an overseas end user. And you might not be familiar with all of those principles, and you might not be familiar with all the things that you need to be aware of. And you're the ones day-to-day working with these people. So you need to understand, when do you need to be raising things with the EOR? If you're changing shift patterns, or if you're having people work overtime or night working, you need to make sure the EOR is aware, because there might be local restrictions around that, or different rates that are applied to salaries. You need to be thinking about if this person's going to be working across borders. Is there immigration issues that the EOR needs to be aware of? So you need to be making sure that you can keep that dialogue with that EOR and make them aware of things that are happening, because they are the employer. They are the facilitator of that employment arrangement. So you need to make sure that even though you're having the day-to-day management, you're keeping that communication there so the EOR can maintain that compliance. And then you want to think about offboarding and onboarding of these individuals. How are you going to go about doing that? What are the considerations at the end of an agreement? So if you were to offboard an individual from an EOR to move to another EOR, or potentially to move to become an employee directly of your company, because you might set up a branch, for example, in a country. So you need to understand what the commercial terms say about that and how you're going to manage that. And it's almost always in those commercial terms, so you want to really get into the nitty-gritty of understanding that. And you want to then understand how you can mitigate that risk around who the employer is. So you want to make sure that if certain countries look at certain elements really specifically when they're looking at a direct employment arrangement, that you ensure you're not doing anything in how you're going to manage that day-to-day relationship to risk that occurring. And different countries look at this differently. In the UK, we haven't necessarily seen tribunals being quick to find a direct engagement model with an end user when they've been engaged via an EOR, but that's different in every other country. So you just need to be aware as to how that will work in practice and if there's things you can look to avoid or manage. Regulatory issues, if you work in a regulated industry and you have someone who's in a regulated role and they're now going to be operating in another country, is that going to create an issue for you? Does this make the EOR model viable for you? And if it does, are there things you need to think about, like your insurances or your regulatory requirements? So that's just something to think about. And data protection. You've got lots of different data issues here. You've got data potentially going to the EOR and vice versa. You've got potentially your client data going to the individual who's providing the service to you. So making sure you're aware of how you're going to manage that. And then finally, immigration. If you need to have someone who's going to be sponsored because they don't ordinarily have the right to work in the country, how's that going to be managed with the EOR relationship? Is it possible for them to be able to be the sponsor? What needs to be implemented in those countries? A lot to take in what I've just ran through, and we sort of whittled through loads of things there, but these are practical things we're talking about. We want to make sure that we, as your lawyers or as advisors, that we're making sure that you're thinking of these practical things, which are not necessarily sort of the more legal compliance elements. These are just the practical things that can come up.
And
I will pass over.
Thank you. It's really interesting. I think that, you have basically given the topics, but each of these matters has a full, amount of things you would need to know and understand about them. So I think it is really important to list them, to have them, as you did, put them all together, because companies need to have a holistic approach, as always in global mobility. So you always need to consider all the different pieces of the puzzle which you need to put together, and you need to consider to be able to be sure that you are being compliant all over, not only on one small, maybe employment law piece, but then you completely forget immigration or whatever, and then you find yourself in a big mess. So you need to be able to have the support to take care of everything.
And it's really important when every time you're going into a new country that you consider these things.
Exactly.
You might engage the EOR originally because you're going into France or wherever, and then look at all these things really specifically when you're engaging for France. And then if you suddenly decide to use them for another country, you make sure you do this again, because they will be different.
Exactly. Now, Hilda, what do you have to comment on this?
Well, first of all, that I absolutely agree with what Amy just said, and I think you listed the right topics, which indeed need to be considered for every situation that you have, both as an employer of record and both on the side of the end user. And for the Netherlands, equally important, all the topics except perhaps a discussion on the actual formal employership. What you also, I think, is important to understand, at least in the Netherlands, is that the employees are in principle entitled to the same remuneration package as your own employees, or as the employees of the end user in the similar position. So that's, at least in the Netherlands, something you need to be mindful of. I think, though, the most important element of the EOR concept for the Netherlands is, which also immediately is a distinction between the EOR and a temporary employment agency, is that the EOR construction itself does not release the end user from its obligations under Dutch dismissal laws. Now, we in the Netherlands are already quite known for our complex dismissal laws, where we require the prior authorization of either the court or a governmental institution before one is able to come to a termination of an employment contract, unless you manage to come to a settlement, an exit arrangement with your employee. But this concept of dismissal and the prior approval of a court is based on dismissal reasons, so valid dismissal reasons, which are laid down in the law. And in the assessment of whether the EOR has a valid reason to come to a termination of the employment, it is not looked at the situation at the EOR, but the situation at the end user. So, for example, if we would have a discussion on the performance of the worker, of the employee, you as an end user are required to provide input on the file and the substantiation of the poor performance file to the employer of record. And that's very important, and also in the interest of the end user, because of this system we have of the prior approval. As long as a court has not granted the termination of the employment continues, and so does the entitlement of the employee to salary payment. We have it for performance reasons, we have it for redundancy reasons. So that is, and there are other reasons such as a disturbance of the work relationship. Those, I think, are the most common topics that we seek termination of the employment for. So it's very important as an end user to make sure to do your duties in that sense of managing the worker that you engage through an employer of record as if you would manage all your direct employees in the same way. Performance management, apply the rules of redundancy correctly, not just to your own workers, but also to the EOR worker that you engage. That is, I think, the most common misunderstanding, I think, when people engage with an employer of record, to carefully consider in the Netherlands.
Thank you, Hilda. This rule of the authorization is incredible from my perspective. I thought we were this complex, and now we are shifting the balance completely, I have to say. So, Michal, what about in Poland? Do you have any practical points you would like to discuss?
Yes, absolutely. So many of the points that you earlier mentioned are equally applicable to Poland. It also starts with the contract, with the arrangement. So make sure what is actually you're offering to your company. So make sure what are the clauses in the contract. Two other points I wanted to briefly discuss is PE risk, permanent establishment. And this is something that you as a client of EOR should take care of, because obviously this is solely your problem. And permanent establishment is related to the corporate tax issues. So EOR would normally, I guess, wouldn't advise on this, because simply it doesn't affect them at all. But that's definitely something that you should consider. If you're an HR team, you should consider with your corporate law department, compliance department. Second point, intellectual property, equally applicable to Poland. As we in Poland officially don't recognize EOR concept, this is passing of IP rights is not regulated by law. And you would have to make sure that the contract between employee and EOR secures as well. And then later, what's more important, IP rights are transferred from the EOR to your firm, to your company, because you should be the owner of intellectual property rights. And this is also something from the contractual perspective you should secure, because actually most of the clients of EORs are IT companies, new tech companies. So intellectual property is actually the essence of actually the work they're doing in the foreign country. What else? Maybe a few words about immigration. So from the immigration perspective in Poland, EOR company can be a sponsor, can be an applicant of work authorization of their employees. However, as of May 1st, we may have quite important change in Poland, which means that now immigration office will be actually checking who is the beneficiary of the work executed by the employee. And in the model where you have EOR, the beneficiary of the work of the employee is actually third company. So if immigration office is diligent, they may actually reject work authorization application on this ground. So this is also very important to make sure that as of May 1st, from the looking at the compliance issues, EOR will be able to issue work authorizations, and then you as a client will be able to benefit from that. This applies only to the foreign nationals who would need work authorization in Poland. So in practice, if you are employing or EOR is employing in Poland Poles or other EU nationals, there's actually no issue, there is no case. But if EOR is employing foreign nationals, it may be an issue. So this is basically the case for compliance team to make sure that right to work continues to be right to work of foreign nationals continues to be possible after May 1st.
Thank you, Michal. This is really, really interesting because again, we're touching, from immigration to employment, and it helps, I think, really letting people understand that there are so many aspects that need to be considered altogether. Now, stepping back and broadening in this final part of our webinar a little bit the scope. We've been speaking of EORs, but in your countries, are there other setups to employ employees in the country if there isn't a branch or a subsidiary of the end user, what we have been calling, let's say, the end user, meaning the company who needs these employees. So Hilda, what about in the Netherlands?
Yes, of course, there are other options. One option could be to directly engage with the employee overseas and set up a separate payroll company. And that's a bit confusing in the terminology that's used in the Netherlands, but a payroll company purely taking care of salary administration and salary payment. That is an option. And I think, Melania, that's also construction.
Yeah, exactly.
In
Again,
Italy,
I think the PE point is really important there. You really need to look into the duties and so on. But even in Italy, you kind of appoint what we call the social security representative. So the employer remains the employer, but there is this payroll company that basically pays social security.
Yeah. Well, and the same in the Netherlands, you can do that. But the downside, potential downside, could be that this will require the company, the employer, to the foreign entity then to engage with an occupational health and safety company in the Netherlands. That is a requirement already when you set up and you only have one employee. This is an obligation that you need to comply with. Next to that, we have an interesting, well, next to our dismissal laws, we also have an interesting arrangement for illness absence, where in case of an indefinite term employment, an employee on sick leave is entitled to continued salary payment for a period of 2 years by the employer, provided they stay on sick leave for that amount of time, for that duration, of course. But that is something that you need to consider and take into account. And next to continued salary payment, there are a lot of obligations and reintegration efforts that you need to comply with, all summarized as illness absence management. The company would have to do that themselves. Compliance with that is very important to avoid the penalty of a third continued year of salary payment. And as you just said, Melania, it holds the same potential risk for a PE risk in the Netherlands as well. So I think there's pros and cons for all structures involved, and it really depends on the company's needs and what's most beneficial to them.
Exactly. And Michal, what about in Poland?
Well, you actually have two options. If you wouldn't like to engage the EOR, but none of them seem to be that beneficial of using the EOR services is actually solving many problems. So firstly, you can, of course, employ directly. But then you have all the hassle of being a taxpayer, personal income taxpayer, social security payer. And for many companies, for many of my clients, they say, yeah, would like to hire somebody, but actually this is too big hassle. So we would have too many liabilities and too many obligations to do that. Second point, it doesn't also really sort out the problem is that if you don't want to establish a separate company subsidiary in Poland, then you can establish a branch. So a branch is just a branch, is not a separate company. And a branch, according to the Polish employment law, it is a separate entity. So from the corporate perspective, it's not a separate entity, but from employment perspective, it is a separate entity. And then a branch becomes employer. But again, even though this is not the subsidiary, then there is still like a bit of effort from the corporate perspective. So in fact, some of the companies would use either option, so direct employment or branch office, but many would say there is a too big effort. So the best solution could be using the services of employer of record.
Thank you. And Amy, do you want to comment on this?
So yeah, you've definitely always got, in most countries anyway, the option of doing the direct employment model. So the individual's hired with the overseas company, but works remotely overseas. I've done that for lots of clients that we work with. It depends how much you want to deal with the compliance steps in doing that. It can be quite logistically difficult if you want to offer benefits, because if you don't have an entity or a branch, then it's difficult to provide those. Pensions can be difficult because sometimes it's difficult to pay into pensions across borders. Insurance is often a tricky one if there's local insurance requirements, and I mean business insurance requirements. Not having an entity or a branch makes that a little bit tricky, but it's completely viable. And if this is a long-term arrangement, it might be an option that you want to take when you consider the commercial cost of an EOR against this being a long-term something you want to facilitate, especially if there's more than one or two people, that might be possible. It's also worth really exploring the contractor arrangement, because often when these people are working overseas, you are changing the way that they are different in how they're set up to a local employee. They are remote. There is going to be some distance there. There is potentially an element of a lack of control over how they're working. They might be working in a different model to your employees. So you might want to look at, well, actually, could this be accommodated under a contractor arrangement? Now, what you absolutely don't want to do is inadvertently call it a contractor arrangement when it isn't. You definitely don't want to do that. But if you're exploring models, that's something to look at as an option. But generally, EORs have an absolute place to enable growth into new markets and long-term or temporary overseas working. It's a really valuable employment model that's utilised by lots of companies.
So thank you, Amy, and thank you really, everyone. So we have 10 minutes left. It seems to me from all our exchanges that basically the market is trying to adapt to the needs we were speaking about at the beginning of the employers, employees. So it's trying to offer, let's say, new solutions to manage an international workforce in a new reality, which we didn't even know existed before 2020. But of course, this falls within legislation, which maybe hasn't always adapted, or in any case is highly regulated in this area. So it is always extremely important to understand what you need to consider, and to, before entering a country, setting up things correctly, taking into consideration the peculiarities really of each country. But then once you do that, it is possible to expand, of course, internationally, and this is, I think, a must nowadays. Before we pass to the Q&As, I don't know if any of the speakers want to give also a last kind of takeaway.
I can definitely jump in. So for me, my key takeaway is for you to consider who are your key stakeholders who are going to be utilising the EOR within your business, and who needs to be involved in the original engagement and compliance management of this EOR relationship. So you are going to need legal to be involved. You're going to want them to help you review those commercial terms and to ensure that things like IP and things like that are being considered and that they're understood by everyone involved. You're going to want corporate tax and finance. Finance will want to be comfortable that income tax and social security is sorted. Your corporate tax team will want to be comfortable that there's no PE risk. You might want to have your risk team involved if there's a regulatory element or insurance element or anything along those lines that might be involved. Procurement might need to be involved depending on how you're going about engaging the EOR. HR need to be involved because they often lead this, so they're going to need to be involved. And IT, don't forget IT, because they will be helpful in terms of managing data and data security and how that will work when this relationship is set up. So it's making sure you bring these people in and you have those people helping you to make sure that you navigate setting up the EOR and managing that relationship long term, so that you can make sure that you've got something set up that's compliant and works for you.
So I don't know, Flo, if you want to, if there have been, we received any questions. Oh, you're on mute.
Sorry, we've received a few questions, and the first one is for you, Melania. Consider the takeover of a company. Would employee employed by an EOR be part of the scope?
So yeah, I think so we then first would need to assess if the takeover is a share deal or if there is instead an asset deal. But in both cases, I have to say, usually, the acquisition concerns only the employees of the company. So those employees who are being leased or so on, it depends if the commercial contract behind provides for the continuation also of these relationships. Often it does. Often if you have a transfer of undertaking, employees will pass, but also the contract with the leasing company, so they may continue. Sometimes in the commercial agreement, it is agreed that they will be stopped before the transfer of undertaking. If it is just a share deal, of course, you are buying the company as is, but then, of course, you can manage these commercial contracts as you prefer. I think what needs to be most considered is always if these employees who are of the employer of record but are working with a company might have the possibility to claim that they are actually employees of the company. So instead of being dealt with, let's say, commercially between the company which is using them and the company who is employing them, they have the right to remain attached, let's say, to the user company as if they were their own employees.
Okay, the second question, can employer of record be seen as unfair competition to temporary work agency, which are usually strictly regulated in many EU member states?
Yeah, I'd be happy to comment on that, because I would like to disagree. I don't think that there's any unfair competition in that sense, because I think temporary agency workers or temporary agencies provide for a different need and a different ask from their end users than employers of record do, where the temporary agencies provide work as more of a contingent workforce and provide aid companies in having their flexible part of their workers, which they need to rely on. Whereas I think employer of record structures are more really aimed at a more specific constructions and more on an individual need. So in that sense, I don't think there's unfair competition. And well, especially not from a Dutch law perspective, because employer of record employees, so what we tend to refer to as payroll employees, are really within the Dutch employment law more considered to be, or are to be treated basically as an employee of your own, employee of the end user. So in that sense, there's quite a, I think the balance is there.
And if I can comment on this, I think one of the messages we are trying to pass through this webinar is that sometimes EOR is it's a commercial brand, which is very useful for companies who are seeking solutions. So they go through it. But then you need to really look in each country, what is the setup of the individual EOR you are contracting with, because in Italy, I've seen EORs who are, they are temporary agency workers, but as they work internationally and they cannot put Agenzia di Somministrazione as a brand, which in Poland and in the UK would mean nothing. They use, of course, EOR to give the sense of what they are doing as kind of service, but then they are also in Italy temporary agencies. So you really need to understand your needs, go and see what is offered by the market, and as Hilda was saying, not see this, I think, difference necessarily.
And hopefully, in the next few years, we'll start to see more regulation in other countries, like we'll follow the Netherlands, and actually have legislation which is clearer and makes it much more easier for everyone to navigate, because I don't think EORs are necessarily going anywhere anytime soon. They are used throughout the world, you know, as a model. So, you know, being able to have some clarity to make everyone's life a little bit easier in terms of engaging with them would be absolutely beneficial. So hopefully we will see that in the coming years.
Next question. What about if the end user then decides to hire directly the employee? How would the transfer of the employee from the EOR to the end user be regulated?
I can answer this question if you allow me. So in Poland, the concept is not regulated by law, which also means that there is no solution to that situation. So in fact, the most common option would be simply to settle with your current employer, which is EOR, and then to be employed directly by the end user, the client that is using or used to use the services. This would be a most common situation, and in fact, often happens. Because many times the clients who are using the services of EORs, they are the companies that are not present in the country. So they, for example, they need some time to establish themselves, to hire new people, to start, you know, operating the country, and then establish the company, and then they're kind of seeking to transfer these employees back on their payroll. However, there is no organized solution. Another option I can imagine would be actually the transfer of the organized part of the company. So this is the concept when one company buys, you know, organized part of the other enterprise, of the other company, and it could be the same here. However, this is not that frequent model as being used, because there is obviously a bit more work to that, and usually the clients are, you know, selecting option number one, which is simply terminating employment contract with the first company and then signing a new contract with the other company, the client.
Okay, thank you very much. Unfortunately, we are running out of time. So if you have any further question, you can contact our panelists directly through the email address that you see now on the screen. We also have a variety of resources and insight on the cross-border employment rules on our website. Don't forget to check them out. For more information on our webinars, you can visit the webinar section of our website to find all the past recording and download the slide decks. While you are on the website, take some time to listen to our podcast, Talking Work, in which we talk about the world of work. Finally, I would like to thank everyone for attending the webinar today, and thank also our panelists for their insights today. So with this webinar will be ending. Thank you and have a great rest of the day.
Thank you. Thank you
Thank you all.
Thank you.
Yeah.